Good afternoon. This is Kathleen Drew, Chair of the Washington Energy Facility Site Evaluation Council, calling our meeting on the land use hearing for Carriger Solar Project to order. Ms. Grantham, will you please call the roll for the Carriger Council?
Certainly. Department of Commerce,
Kate Kelly, present.
Department of Ecology,
Eli Levitt, present.
Department of Fish and Wildlife,
Mike Livingston, present.
Department of Natural Resources,
Lenny Young, present.
Utilities and Transportation Commission,
Stacy Brewster, present.
for local government and optional state agencies for the Carriger Solar Project, Klickitat County, Matt Childs,
Matt Childs, present.
the Assistant Attorney Generals, Jenna Slocum,
Jenna Slocum, present.
John Thompson, for our Administrative Law Judge, Micah Laripa,
Present.
for EFSEC Council staff, Sonia Bumpus,
Present.
Amy Hofkemeyer,
Present.
Amy Moon, Stu Henderson,
Present.
Joan Owens,
Present.
Dave Walker, Sonia Scabland, Lisa Massengale,
Present.
Sarah Randolph, Sean Green, Lance Caputo,
Lance Caputo, present.
John Barnes,
John Barnes, present.
Osta Davis, Joanne Snarsky,
And Snarsky, present.
Alex Shiley,
Present.
and do we have someone for the Council for the Environment? Chair, we have a quorum for the regular council and for the Carriger Solar Council. Thank you.
Thank you very much. With that, I will ask our Judge Micah Laripa to preside over this hearing. Judge Laripa.
Thank you, Chair Drew, and good evening, ladies and gentlemen. So the time is now 5:02 p.m. on May 16th, 2023, and this is the land use consistency hearing in the matter of Carriger Solar Project, EFSEC docket number EF-2300001. The purpose of the hearing, per Washington Administrative Code 463-26050, is to determine whether at the time of application, the proposed facility was consistent and in compliance with land use plans and zoning ordinances. At this hearing, which is required under RCW 8050-090 and Washington Administrative Code 463-26060, the public will be given an opportunity to provide testimony regarding the proposed project's consistency and compliance with land use plans and zoning ordinances. Land use is the subject matter for today's hearing. It is not general commentary about the project. Argument and testimony attorneys for the applicant and the county, and any relevant testimony as to whether or not the proposed facility was consistent and in compliance with local land use plans and zoning ordinances at the time of application, was submitted to EFSEC and will be accepted during the land use consistency hearing. Speaking time at the hearing will be as follows. For the project applicant and the county, each will be afforded 15 minutes to present their argument and testimony. Following that, I will begin opening the floor to public testimony. Each member of the public who wishes to speak regarding land use in this matter will be provided 3 minutes of time. At the 3-minute mark, I will let that person know that their time has expired and give them an opportunity to conclude whatever statement they were ready to complete. So there will be some grace with regard to time. However, if it goes much beyond 3 minutes, then I will need to put a stop to that testimony. As far as the procedures go, or rather when parties are speaking, and this will apply to both the applicant and the county, as well as any member of the public, When you begin speaking, I will ask you to please state and spell your name for the court reporter. And also, I'd like to remind you to please speak slowly and clearly to ensure that we have an accurate transcript for tonight's hearing. With that, before we move to the applicant, Chair Drew, do you have anything else that you'd like me to cover?
Thank you. No, that covers our meeting for tonight.
All right, thank you, Chair Drew. So with that, the applicant, Cypress Creek Renewables, will now have 15 minutes to present its argument and testimony.
Thank you, Judge Larippa, and good evening, Chair Drew and council members. I am Linda Atkins, that's Linda, A, T as in Tom, Kins. I'm an attorney with Davis Wright Tremaine, and I'm here this evening representing the applicant, Cypress Creek Renewables, with respect to the Carriger Solar Energy Facility project. I would also like to introduce a few people from Cypress Creek who are attending this evening, and they will be available to answer questions should the council have any. We have Mr. Ty Wallace. He's the Senior Director of Western Transmission for Cypress Creek. We have John Hanks. He's Associate Director of Development for Cypress Creek. Lauren Altick, the Project Developer for Cypress Creek. And Leslie McLean, she's a consultant and a project manager for Tetra Tech. Next slide, please. One more slide, thank you. So as Judge Larippa announced in his introduction, the subject of our hearing this evening is whether under RCW 8050-090, the proposed site is consistent and in compliance with county land use plans and zoning ordinances on the date of application. And under EFSEC's regulations and past orders, the applicant's task in this type of hearing is to demonstrate that the statutory threshold for land use consistency has been met. Further, under EFSEC's prior precedents in state law, that test is whether local land use provisions prohibit a site expressly or by operation clearly, convincingly, and unequivocally. If the site can be permitted either outright or conditionally, it is consistent in compliance with local land use provisions. Next slide, please. So the project—
May I pause for just a second? I am not seeing the slides. I don't know if anyone else is having that challenge.
I'm able to see them, Chair Drew.
Okay.
But during the brief pause, I would like to remind anybody joining us by phone to please go ahead and mute your handset. Thank you.
Okay, that's just on my screen. I will figure it out. Thank you.
All right, I will proceed. So the project description was presented at the council's last meeting on this project on April 25th. And I really just want to highlight here that the applicant has submitted a very complete application for site certification. It includes the listed studies that you see on the slide. And the one I really want to call to the council's attention this evening is attachment B, that's the land use consistency review. And that document discusses in a great deal of detail how and why this application is consistent with the land use plans and zoning ordinances of the county. There are extensive site studies. You'll see them listed there, and micrositing has been applied to the project site to ensure that the smallest footprint possible that avoids all sensitive areas has been utilized. Next slide, please. So before I discuss the project consistency with plans and ordinances further, I just want to address at the outset something that I believe that we may hear from the county or the public later this evening. And that is a moratorium that the Klickitat County Board of Commissioners passed on January 10th, 2023, and that was to establish a moratorium on the acceptance of applications for large-scale solar projects. So the nature of this moratorium under EFSEC's existing precedents and state case law is that does not regulate how land is used, and it does not meet the definition of a land use plan or a regulation under RCW 8050-020, which is the set of definitions that EFSEC applies in its proceedings. So given that, this moratorium is not relevant to the proceeding this evening, and it doesn't affect the council's determination of land use consistency. Next slide, please. So EFSEC follows the rule that land use plans are guides and not mandates. And that also is consistent with general state land use law. And the primary question then under the Klickitat County Comprehensive Plan is whether the land use element of the plan contemplates the proposed use. Comprehensive plan elements that don't meet that type of a definition are not strictly relevant for land use consistency purposes. So this site for the project is designated agricultural forest under the general land use plan. That's the use designation. And that is a designation that allows as a conditional use any non-agricultural or non-forest use when that use is not in conflict with agricultural or forest practices and does not take out of production more land than is reasonably necessary for the proposed use. So again, I would refer to the way in which this project has been microsited to ensure that it is using the smallest possible footprint within the project study area for the actual solar panels and the associated infrastructure. It's been designed to avoid all sensitive areas. The participating landowners will be able to continue to conduct agricultural uses on portions of their property that are not being used for the project. There's no high value or high production agricultural lands that are within the project maximum extent. So that's the area in which the panels and the infrastructure will be placed. There is only a very small amount of irrigated land within that project maximum extent. And there's no forest land affected by the project. There'll be no trees removed or affected. And as I will discuss in a bit more detail later in the presentation, the zoning classifications that the county has adopted within this agricultural forest general land use plan designation, extensive agriculture, and rural zoning districts are districts that also allow the use. Next slide, please. So as I said, while the comprehensive plan is a guide and not a mandate, there are a number of county goals and policies that are expressed in the comprehensive plan that the project has been designed to respond to and to incorporate mitigation measures and avoid having impacts on these values. And a few of them that I want to highlight are first of all, that the county policies do support our statewide goals for renewable energy development. It's not, we all know that our state has placed a very high priority on moving to renewable energy sources for our electrical infrastructure, and this project is consistent and supports that goal. The utilities element of the comprehensive plan also encourages energy production in Klickitat County, and this project relies on existing utility corridors as encouraged by the comprehensive plan goals. And the project incorporates, as I have been saying, many design features and mitigation measures to ensure that it will be responding to the various policies and goal focuses that you can see on the slide here. Next slide. So this slide just continues the public services response part of the project. there are a set of best management practices that the project is employing to address the various aspects of the operation and the construction that could impact those goals and policies. And I would in particular highlight the stormwater management, best management practices. So these include things like spacing the panels and revegetating the surface under the panels to allow natural infiltration of rainwater, and designing the project so that it responds to all of ecology's requirements to manage stormwater on site. And the project does incorporate a number of measures that are designed to ensure fire safety. There is battery energy storage as a part of the project, and that storage uses state-of-the-art fire prevention and suppression systems. And there will be an emergency response plan provided to the fire protection district in the county. Next slide, please. So part of the goals and policies, the comprehensive plan, are that a project be made compatible with its environment. And this slide shows two of the photo simulations that have been prepared for the project. These are part of the much more extensive visual assessment report that the applicant has submitted in support of the project. And you can see in these simulations that the project will not block any of the vistas and views to the mountains or the other scenic resources of the county, and will generally be consistent with other man-made elements that appear in the environment, for example, fence lines, power poles, and transmission lines. Next slide. So this slide is the map from the county zoning ordinance, which shows the zoning classification and the energy overlay zone, which overlays the zoning classification. So the project site, you can see, is outlined in the purple. And you can see from this slide how the project is laid out so that it provides corridors for wildlife and responds to the need to keep the project infrastructure away from sensitive areas such as streams and wetlands. And you can see the extensive agriculture district is in the yellow and the general rural district is in the green. And most of the project is within the area that's cross-hashed in red. That's the energy overlay zone. So that is a zone that was adopted under Klickitat County zoning ordinances to accommodate renewable energy projects, which include solar energy projects. Next slide. So once again, the zoning classifications, the extensive agriculture district, the general rural district, and the energy overlay zone. So each of those classifications allows a solar energy facility as a use. And the energy overlay zone, solar energy facilities are actually a permitted use. They're permitted outright. And in the EA zone and the GR zone, this type of a facility is allowed as a conditional use. Next slide. So under the county zoning code, you can see the definition of a conditional use. That's a use that is permitted when it's authorized by the Board of Adjustment and subject to reasonable conditions or restrictions, which would render the use compatible with existing and potential uses in the vicinity, which are permitted outright. So the essence of a conditional use, and this is as a matter of county code, and it's also as a matter of our general land use laws and principles in this state, is a use that is permitted subject to conditions. So in the Klickitat County Code, there are not specific conditional use approval standards that are associated with that definition that I read. So from that extent, the project would look to have conditions to make it compatible with environmental analysis under SEPA and any applicable zoning standards within the code. And the ones that I would point the council to would be in the EOZ. There are actually a list of topics that the EOZ calls for both wind and solar projects to be made consistent with. These are all topics that the project has been designed to accommodate and respond to. Next slide. So very briefly,
just as a brief time check, I just wanted to let you know so you can plan to use the time as you see fit, but there are approximately 2.5 to 3 minutes left.
Okay, thank you.
Sorry, 3.5.
Okay, thank you. So Ms. Grantham, if you could just move quickly through this slide and the following 3 slides. So these slides really just highlight the way in which the project is also designed to be consistent with the Klickitat County Critical Area Ordinance. So that is part of the applicant's responsibility under the code to be responsive to that ordinance. And there are many mitigation measures and project design features that have been incorporated to respond to those directives. So in conclusion, I want to bring us back to the test, which is whether local land use provisions prohibit a site expressly or by operation, clearly, convincingly, and unequivocally. The use is permitted use in the energy overlay zone, and it is allowed as a conditional use in both the EA and the GR zone. Therefore, it is consistent and in compliance with local land use provisions as defined by EFSEC. And I would just highlight that the county code actually incorporates this objective, which is highlighted on the slide in County Code 1902-030, which really calls for a balancing of the uses within the allowed zones and to respond to changing conditions and requirements. And given that both solar energy and agricultural and general rural uses are allowed in the zoning districts that are applied to the project, and the project can be sensitively sited so that it does not become incompatible with those uses, the council should find that this project is consistent with the county's land use plans and zoning ordinances. And that concludes my presentation.
Great, thank you, Ms. Atkins. Now to move over to the county, it is my understanding that there are 2 speakers appearing on behalf of the county tonight. Would those 2 speakers please identify yourselves?
Lori Zoller. Go ahead.
Klickitat County Commissioner Dan Christopher.
And County Commissioner Lori Zoller.
All right, and with regard to the county's time, I'll leave it to you to decide which order you'll speak in, and also your allocation of the 15 minutes. Have you decided together in advance of this meeting which one of you would like to speak first?
I will go first, she will go second, and I don't think we will need the full 15 minutes.
Correct.
Then please just go ahead and state and spell your name for the record, and then please go ahead and begin with your argument or testimony.
My name is Dan Christopher, DANCHRISTOPHER. My testimony is thank you, Chair and members of the board. I am Klickitat County Commissioner Dan Christopher. I want to remind this board that Klickitat County has clearly demonstrated that it is pro-green energy as long as the projects are sensibly sited. Under RCW 35A.63.220, Klickitat County has created Resolution 00823 for a moratorium that states, and I quote, that all applicants for large-scale solar projects over 1 acre in size for time will not be accepted for at least 6 months. This was passed before the Carriger Solar Project submitted its application to EFSEC. Resolution 04323 created after the public hearing on the moratorium goes even farther and states, quote, no land use applications associated with large-scale solar projects over 1 acre in size, which are the townships and range, quote, shall be accepted as either consistent or complete. With that, I understand the opinion by some that a moratorium is not a land use decision. What it is a pause button. Klickitat County hit the pause button, just like the governor has hit the moratorium pause button many times over the last few years with things like eviction moratoriums. So I question if the state is going to honor our moratorium like it insists the county honors theirs. Now, yes, Klickitat County could have and still can enact emergency zoning ordinances that clearly, convincingly, and unequivocally ban all solar development in the county. We're trying not to do that. We're trying to sensitively cite projects, but we may have to change if we feel that EFSEC is going to undermine the local decision-making process on where we feel projects can or can't be sensitively cited. Under Klickitat County Code, all projects located outside the energy overlay zone will go through a conditional use permit process. This allows our citizens that sit on that board to judge if a project is too large or not sensitively cited or in any way non-consistent with Klickitat County's customs and cultures. This public hearing today that we are mere spectators in is not a consistency hearing presided over by Klickitat County residents, and it is a hearing of which we have one voting representative that will preserve our customs and cultures. With that, Klickitat County has also submitted a packet for review, providing the evidence that we can obtain on a limited, incomplete, and inaccurate data submitted by the Carriger application so far. With that, I'm going to freestyle a little bit, and I'm going to certainly hope that you all don't take the testimony given by the attorneys for the applicants as true and factual, as they've probably never been to this land either. I would certainly hope that the people on this board would care enough for this community to at least come out and drive the project and then look at the application that was presented to you and look at the legal blah, blah that was just given and be able to call BS. Oh, you can't see this project from Goldendale. I can see it from the Goldendale Community Services Building. I can see it from the courthouse. You can see it from the freeway. You can see it from so many places all over that valley. And they showed two pictures that I don't even know where they're taken. They found some boring road with no houses on it and said, see, this is what it looks like in Klickitat County. It's absolutely misleading. We at Klickitat County cite our projects, of which we have solar projects, we have windmills, we are going to have pump storage, we're going to have more solar, but we do it in a sensitive way. We put the solar panels that are going to affect people in the sagebrush where there's no houses around. Nobody's got to look at them. Nobody's got to ruin your view shed, because that's all we have going for us in this valley is our view shed. That's why people move here, is our view shed. And for them to say that nobody's going to see the view, I'm sorry, this is going to absolutely destroy the view of this community. It's going to cause economic disparity in this community because these jobs are not going to be our locals. The unions testify, but they've also told us that there's only 15 union laborers in Klickitat County. So yes, we're providing jobs to, Clark County, but it doesn't help us. And what you're going to do is you're going to cause people to not want to move here anymore because of the destruction of the view shed. So we know how to do green energy projects. We've been a partner with the state of Washington for decades to put in green energy projects, but we've been smart enough to cite them sensibly where it doesn't affect our residents, and our residents are fine with that. This project absolutely affects a third of the population of this county, and you're putting it right next to the only poor and impoverished community in our county. And what you do today on this one sets a precedent on the other three that want to surround the community. So with that, I'm going to be done freestyling in my anger, but I'm going to call on you to make the right decision in your sensibly citing. And I hope I can trust on you to find that this, because of the moratorium, is not consistent. Because I feel that if we cannot trust the state to trust the people of Klickitat County on where these could be cited, I feel you leave me no other argument but to change and make an emergency zoning ordinance that clearly, convincingly, and unequivocally bans all solar development in the county. And you will no longer have a green energy partner in Klickitat County. I feel that's where this is going. I hope it's not. I hope we can work together to sensitively cite projects, but I'm losing faith. So with that, I'll be done. Thank you all for your time. Sorry if I'm a little heated. With the first 15 minutes of inaccuracies, I got a little worked up. I apologize to the chair. Have a nice day.
All right, thank you, Commissioner Christopher. Commissioner Zoller, if you would please state and spell your name for the court reporter, and you may begin your testimony or argument.
And how many minutes do I have left?
It looks like we're at 8 minutes and 30 seconds.
Perfect. Thank you. And I probably won't need that. My name is Lori Zoller, Lorizoller, and I'm District 2 Klickitat County Commissioner. I'm speaking this evening for myself and my constituents. I, too, unfortunately, am going to freewheel it here, and I'll try to stay on task. After hearing the previous testimony, I, too, have to refute some things. I had other testimony prepared, but in light of what I heard, I'm pretty disappointed. The applicant began their testimony discrediting the Klickitat County Comp Plan, saying it was only a plan, didn't mean anything, wasn't worth anything to take a look at that. But when they continued through their testimony, they relied back again and again and again for justification to our comp plan. The comp plan does speak to our customs and cultures, and it is a plan that drives how we create our ordinances and regulations. The county comp plan, the energy overlay zone, the critical area ordinance, the shoreline management plan are all aged documents and do not speak to the condition of large-scale solar. In fact, all are currently being updated and under review to bring them into today's day. So to rely on the fact that the plan meets, their application meets siting requirements because of the EOZ is false. The EOZ is lacking any information to large-scale industrial solar. It only gave a nod to solar because back when it was created, we knew nothing about solar, only that they went on the top of people's rooftops. So to say it belongs and covers industrial solar is false. The CAO and the SMP are being updated as we speak, as required by Department of Ecology in the state. Those documents do have expanded regulations coming. The regulations that they have now also cover some of the things that weren't included in the application, and that is that the Goldendale Plateau has long been considered a critical recharge area for the Little Klickitat and Klickitat rivers. The aquifers that are all connected through that plateau filter water like a funnel as it flows to the Klickitat and Little Klickitat rivers as clean water. Both rivers are home to the Mid-Columbia steelhead, a listed species, which was not addressed in their application. Both rivers have multiple overlays of federal, state, and county regulations in place for protection that this project may put at risk. It needs to be well studied to make sure that stormwater runoff and changes in water and water quality and water amounts, which could severely impact TMDLs and CFS that have been set for both these rivers already to protect the fisheries. Years of studies were conducted and parameters were set for this area for the aquifer protections. And in light of so many inconsistent items, an expedited process would be a travesty for this area. Please ensure a full EIS so that forgotten and unnoted items like the fisheries and the connection to the Mid-Columbia steelhead are addressed. And also, please take to heart that these documents that they're relying their application are out of date and are being updated and do not talk back to what industrial solar really is. Thank you.
Thank you, Commissioner Zoller. So now it's time to move on to members of the public who wish to speak. Ms. Grantham, do you have the list and order that members of the public signed up to speak?
Yes, I do.
All right, thank you. So if you would please call off each name, and when Ms. Grantham calls your name, once again, please state and spell your name for the court reporter. And then you'll see if you are viewing us on video, you'll see the clock because I do understand that some people are calling in by phone. When the 3 minutes is up, I will let you know that your time has expired and give you an opportunity to finish your remarks. I will ask that everybody not speaking, please remain on mute, and show each person who wishes to speak the same courtesy that I'll expect when you're speaking. So with that, Ms. Grantham, would you please call the first member of the public who would like to offer testimony tonight?
Certainly. The first name I have is Justin Sellers.
All right, Mr. Sellers, if you're with us, please go ahead and unmute if you're muted, and state and spell your name and begin your comments.
I'm not hearing Mr. Sellers, but really quick, Judge, I think Chair Drew might have dropped off. Oh, she's joining back in as we speak.
Okay, we'll go ahead and stand by.
There she is. Welcome back, Chair Drew.
All right, so what we'll do then is we'll move on to the next member who signed up, and then before we conclude, we'll circle back and see if Mr. Sellers has joined us again.
Okay, so the next name I have is Greg Wagner.
And Mr. Wagner, if you're on the line and trying to speak, you may still be on mute. Please go ahead and unmute yourself whenever you're ready, sir.
My name is Greg Wagner.
All right, and if you would please spell your name for the court reporter, and then you may begin your comments, sir.
My name is Greg Wagner. Gregwagner. I'm with the group CEAS, Citizens Educated About Solar Energy. Klickitat County has a rich history of farming and ranching, and that is what the comprehensive plan is all about. The project is inconsistent with land use and is incompatible. The Cypress Creek ASC is inaccurate. The 266 pages is flawed, has many omissions and inaccuracies. It cannot be counted on. It was provided, much of the information was provided by Tetra Tech, a company that's under investigation. EFSEC itself has asked for a data request dated 5/9 for additional information. CEAS members request that this virtual consistency hearing cease and be rescheduled until a later date. If this applicant could provide answers prior to this land use consistency hearing, EFSEC and its consultants would not have adequate time to review their answers to ensure they are accurate. CEAS members, the public, and Klickitat County government would not be given adequate time to review these answers. Many of these answers were provided by Tetra Tech and should not be accepted considering they are being investigated for fraudulent reporting. EFSEC's questions should be forwarded to and reviewed by the appropriate agencies for accuracy. These are the reasons why this land use consistency hearing should be canceled and rescheduled. If this certification process is to be conducted in a fair and impartial manner and in compliance with RCW 4236, adequate time needs to be given to all parties. CEAS members are requesting the land use consistency hearing be postponed. And we heard the applicant's lawyer say that our moratorium, our ordinances had no value. And then they turn around and they quote all our EOZ and our codes as having value and importance in their consistency. I feel that our moratorium should have as much weight as the ordinances that we have in place that they want to use in their favor and against us. This is unfair to the citizens of the county. We'd like to have input in what goes on in our county and not have Cypress Creek pay somebody to give them the answers they want. And the picture they showed of the view shed was on Fish Hatchery Road. It doesn't show what the real landscape looks like. This project will be seen for miles, and it will disrupt people's lives, their property values. It would destroy the land. Our water counts on the recharging of our potable aquifers. It's in violation of the critical area ordinance. Many of their studies are false, inaccurate, misleading. Even on April 25th at their meet and greet with EFSEC, their displays were wrong. Ty Wallace gave out false information to the fire commissioner, Rule 7. Everything that they say is always questionable. They'll say anything to get their projects permitted. So in light of that, this project should not be certified. It should go to adjudication. It should be fully studied. All their studies should be re-examined, especially if they were done by Tetra Tech. They have proven to be inconsistent and inaccurate with their information. That's all I have to say. Thank you.
All right, thank you, Mr. Wagner. And for future speakers, I understand that part of the comment, and it was limited, so I didn't want to interrupt Mr. Wagner's comment. But with regard to any motions to continue the land use hearing, further motions will not be considered. This is the time, date, and venue for the land use hearing pursuant to the notice that was issued on April 27, 2023. So for future speakers, I will ask you to refrain from making any further motions regarding the procedures for this evening's hearing. With that, Ms. Grantham, who is our next speaker?
Our next speaker is Deb Wagner.
All right, and Ms. Wagner, you're welcome to go ahead and unmute. And if you'd like, please state and spell your name for the court reporter and then proceed with your comments.
My name's Deborah Wagner, DEBORAHWAGNER. Can you hear me?
Yes, ma'am.
Okay. These are my comments why Carriger Solar project should not be certified. The Clean Water Act is a federal law enacted in 1948, and amendments have been made in 1972 to protect our water. Where Carriger proposes to put their sites, water is present. This is our potable water for the county, potable water for our fish, which is right across the street. This should not be damaged. Our water should not be contaminated by solar sites. With all the chemicals in the solar panels, this would be irresponsible to do. RCW 8910.005, written to preserve farmland. Again, where Carriger Solar proposes to put their solar sites is on our farmland. This is our food. This is food for everyone, not just Klickitat County. This food goes farther than Klickitat County. We are the Northwest growers, very important to sustain life. One more thing I would like to say is I agree with everything that Dan Christopher said, our commissioner and Lori Zoller, and I thank them very much for standing up for our citizens. Thank you.
All right, Ms. Wagner, thank you for your testimony. Ms. Grantham, who's our next speaker this evening?
Our next speaker is Delmer Eldred.
All right, and please go ahead and unmute, state and spell your name for the court reporter, and you may begin your comments. Do we have Delmer Eldred on the line? All right, hearing no one, Ms. Grantham, please move to our next speaker, but just put a note to call Delmer Eldred's name once again, once we move through all of those who've signed up to speak.
Certainly. The next person I have on the list is Sherry Bosky.
And if you're on the line, please go ahead and unmute, state and spell your name for the court reporter, and then proceed with your comments.
I see that she's trying to speak, but we're not hearing her come through, unfortunately.
Can you hear me now?
Yes, we can.
Yes, we can. Okay. Dear EFSEC,
Nope, sorry.
my name is Sherry Bosque, SHERI, BOUSQUET. I live in Hewsum, Washington. I care about my seat of my county, and I do not want it surrounded by industrial solar. I do not believe you have the territorial jurisdiction. Come into our county and tell our county how we will use our land. I do believe that you must listen to our county planning. We will not allow permits. We will not allow this in our moratorium. You do not have territorial jurisdiction. You don't have it.
And Ms. Bosky, it appears that you went back on mute. Have your comments concluded? Ms. Bosky, it appears that we're either experiencing technical difficulties or you may have inadvertently muted yourself. If you have further comments, please speak up and let us know that you're there. All right.
I guess I do have additional time. And what I'm saying is I do not believe that EFSEC has territorial jurisdiction in our county. If you do not have a state law, if you do not have a federal law that says you can site large-scale solar in our county is the one that would make the decision. You're overstepping your jurisdiction. I mean, if you want to do eminent domain on the property, do it. You know, just do it. Just eminent domain it as a state. But I don't believe you guys have the authority to come into our county and tell us what we're going to do with our egg land. That's ridiculous. I don't care who puts up a substation. You know, they just went and did it, and now they're like, oh, now we're going to be a solar wasteland. No. You guys need to seriously step off and realize that our county has jurisdiction. Thank you.
All right. Thank you for your comments. Ms. Grantham, who is our next speaker?
Our next speaker is Justin Bosque.
Right, and if you're on the line, please go ahead and unmute and state and spell your name and then begin your comments.
I believe we're having the same issue as before where it shows he is attempting to speak, but we are not hearing it come through.
All right. We'll give it just a moment and then is Justin Bosque present, or are you able to hear us? And Mr. Bosque, it appears that you're experiencing technical difficulties. If you can try to speak, if I'm not able to hear you, though, we'll move on to the next speaker and then call you again at the end. But please go ahead and try one more time, sir. All right, Mr. Bosque, if you can hear me, we're going to move to the next speaker just to keep comments moving along, but we will call you again before comments conclude for the evening. Ms. Grantham, would you please call the next person who signed up?
Yes, the next person I have on the list is Dana Peck.
And Dana Peck, if you're on the line, please go ahead and unmute and state and spell your name for the court reporter.
Hi, can you hear me okay?
I sure can.
Okay, my name is Dana, D-A-N-A, and the last name is Peck, P-E-C-K. Way back when I managed the energy overlay zone process, and the one aspect of it that I'd like to bring to the council's attention is that the commissioners are certainly right that we didn't foresee large-scale solar when we did this back in 2004 and 2005. But we did do, and this is the piece that's been sort of lost when we refer to the energy overlay zone, is although we're not a Growth Management Act county, we did do a programmatic environmental impact statement on the entire county. And that's what informed the language that was subsequently put into the comprehensive plan and zoning. And one of the things that we looked at specifically was a preferred alternative that allowed, well, we looked at three alternatives on the procedural side. One that would prohibit any kind of energy project outside the energy overlay zone. And the preferred alternative that we selected addressed the idea that, okay, within the energy overlay zone, you know, there's a certain amount of allowed uses. Well, let me just read it. It's easier to read it than to try to summarize it if you don't mind, because it's short. This is page 2-18 of the county's programmatic impact statement dated September 2004, section 2.5, preferred alternative. The FEIS includes a preferred alternative combining procedural alternative 1 with the limited geographic alternative. The preferred alternative would allow wind, gas-fired, biomass, and solar energy development to be permitted outright within the overlay, subject to site-specific SEPA review and mitigation and compliance with relevant local, state, and federal laws and regulations. Energy proposals outside the overlay would be subject to the existing county conditional use process. And this was incorporated into the comprehensive plan and zoning through county ordinance 03-1505, the March 15th, 2005. So again, although the specifics of grid scale solar weren't addressed at that time, the concept of solar certainly was, and it isn't just a quasi-judicial or legislative action that the commissioners took. It was based on a programmatic environmental impact statement, which is a relatively odd duck in the world of process, but we felt that it was a way of underpinning the other decisions that were made. And that concludes my remarks.
All right, thank you, Mr. Peck. Ms. Grantham, would you please call our next speaker?
Next speaker is Russ Hansen.
Yes, can you hear me?
I sure can, thank you.
Yes, my name is Russ Hansen, R-U-S-S-H-A-N-S-O-N. My wife Amy and I live directly adjacent to the proposed project, and the development is called McCabe Meadows, which consists of 240-acre development that was created by James Fair as 12 parcels, which are 20 acres each in size. In 2005, Mr. Fair created protective covenants for this development, and they were recorded with the Klickitat County Court. Each buyer of a parcel in this development acknowledged these protective covenants when they purchased the property. My wife and Amy bought 2 parcels of McCabe Meadows development in 2012 and took comfort in knowing that these protective covenants would limit the type of uses that would be allowed in this development. Cypress Creek Renewables has released at least 6 parcels in this development, totaling 120 acres from 3 different landowners, none of them who live in the development. This is a direct violation of our protective covenants and not consistent with the land uses in the development. Section 3 of the covenants regarding uses. The second sentence states that any owner or occupant may make ordinary residential or recreational uses to that portion of the property they have interest. Industrial scale solar and lithium ion battery storage is definitely not a residential or recreational use. Again, this is a direct violation of our covenants in this development and not consistent with the land uses. Section 5 of our covenants regards activities. The last sentence states, no noxious thing or use of the property shall be allowed. Solar panels, if cracked or broken, have noxious and toxic materials that can easily contaminate the soil and the private wells in this development. A 2-acre lithium battery storage in our development directly behind our homes is a noxious and toxic time bomb. This would contaminate our air, soil, private wells, not to mention be a extreme fire hazard to the residences here. Again, this is a violation of our covenants and our land uses in this development. When Mr. Fair wrote these covenants, it was clear that he intended for the land to be developed for residential and recreational purposes, not industrial uses like solar. And when parties bought property in this development, based on the protected covenants, they would have never imagined that industrial solar would be allowed in our development. Protected covenant case law states that covenants are a legal binding contract between landowners. It further states that covenants that are consistent with applicable law will not be superseded or terminated by zoning ordinances that are not consistent with those covenants. In March of this year, my wife spoke with Joanne Snarsky of EFSEC about her covenants. She stated that EFSEC has not ran into this before and she would consult with the Assistant Attorney General. She later advised us that the AG's office stated that EFSEC has no authority or has authority over state law, county and city ordinances and zoning, but has no authority over protected covenants. So by its own admission, EFSEC has no authority over our protective covenants. Therefore, that portion of the Carriger project that is located within the McCabe Meadows development cannot be approved. I will be submitting my testimony along with a copy of the protective covenants and parcel maps via email. Thank you.
Thank you for your testimony, Mr. Hanson. Ms. Grantham, would you please call our next speaker?
The next speaker I have is Amy Hanson.
Good evening, committee and Judge Micah. Can you hear me?
I sure can. Thank you, Ms. Hanson.
Okay, thank you. My name is Amy Hanson, AMYHANSON. As my husband just said, we live directly behind the Night Road substation and are going to be directly affected by the Carriger project. In listening to testimony this evening, I would ask that the committee actually read our energy overlay zone document and ordinances that were created. It mainly addresses wind. There's very few paragraphs in there that even address solar, and they were expected to be small in size and number and sensitively cited. The document was created in 2004. I think it was amended maybe once, but this area has changed a lot since 2004. This is an area that is highly populated, just right outside Goldendale city limits. I would ask that the committee come take a look, come drive out here, take a look and see. This is rolling terrain that goes, slowly, higher as it goes towards the Simcoes, and this will be visible from town, from everywhere. So for Carriger, the attorney to say that this will not visually impact us is not correct. Please come take a look. Please look at where they're proposing this project. I've read the county comprehensive plan many times, and basically it says that activities should keep the rural character of our county. Where we live, we are surrounded by productive farmland. Productive farmland. It is, drive out here. It's being farmed right now. This is not sagebrush. This is not rocky country. This is beautiful farmland that is being used. My husband and I raise sheep. We have horses. We bought this property for the view, for the proximity of close to town. I just don't understand how an industrial project can be sited on agricultural land. When we moved here, we were paying, our tax base was through the county was residential, and we're paying a higher tax rate on one of our parcels for the view. So the county recognizes that our view is worth something. This is our quality of life. This is the quality of life for everybody surrounding us. And once this, if this is approved and this is turned into industrial solar, no matter what they say, it can never go back to the farmland, the beautiful farmland it is. It'll be ruined forever. So please, thank you for your time this evening. And please come take a look at where they're proposing this project before you make a decision. Please come to our home. I invite you all. Thank you.
Thank you for your comments, Ms. Hanson. Ms. Grantham, would you please call our next speaker?
Yes, I have Jean Callan.
And if Jean Callan is on the line, please go ahead and unmute yourself and state and spell your name for the court reporter, please.
Can you hear me?
I sure can. Thank you.
Okay, thanks. This is Gene Callan, Gene. Last name is Callan, Callan. My wife and I live directly adjacent to this project. In fact, our domestic well is within a few hundred feet of the panels. Just to give you some context, tonight, because it is a land use hearing, by the way, one which I think is probably one of the most important land use hearings we've had in the history of our county. I'm a little appalled that we didn't have this in person. This is such a huge topic that it should have been in person, and I think some of the technical difficulties are proving that. But that being said, I had 3 land use items to cover. I think our commissioners did a great job of covering 2 of those. So I'm not going to go into hardly any detail on my first 2 and applaud our commissioners for covering those. The first one was the fact that we do have the moratorium in place, the moratorium that was in place over a month before the Carriger project was submitted to Cypress. The second one was the fact that we have a requirement inside our EOZ, and I'm not sure anyone has talked about it in detail yet, that there is an environmental impact statement required for every project that goes through the EOZ via a legal agreement that was executed back years ago. And so the fact that there hasn't been an EOZ and there's a bunch of components of that, EOZ and EIS, that there are a bunch of components that need to be included in that. It needs to happen also as part of this land use process. My last item is, it talks about, I titled it Common Sense, and someone may say, well, this is a land use hearing. We need to parse the legal language and review the RCWs and the entitlement process. Common sense really doesn't come into play in this meeting. And I would push back and say, that's baloney. If you look at all of our zoning, they always start with the purpose of that zone. There's a global goal to that zone. For example, our extensive agriculture talks about continuing practice and preserving lands best suited for agriculture and preventing conflicts. And our EOZ talks about sensitively siting projects. For this project to be called, micro-sited and sensitively sited does not factor in a common sense filter. If we were to use that filter, I don't think anyone, whether you're for this project or against this project, would argue that we are not turning our ag land into an industrial use. And that's the common sense factor that we're faced with in this county. Thank you very much.
All right, thank you for your comments, Mr. Callan. Ms. Grantham, would you please call our next speaker?
Next speaker I have is Dave Barta.
Good afternoon. DAVEBARTA. And you can hear me, correct?
Yes, sir.
Thank you. Chair Drew and council members, good afternoon. Thank you for the opportunity to testify on land use related to the Carriger Solar Project. According to the applicant's presentation, they are in full compliance with Klickitat County land use and zoning. The applicant further states that the moratorium related to industrial solar siting is not a land use action. History, however, proves that assertion false. In 2013, shortly after marijuana was legalized across the state, Klickitat County placed a moratorium on sale, distribution, and retailing of marijuana products in the county. Within a few months, the commissioners tasked the Planning Commission with considering ordinances or limitations in the county on growth and sales of the product. After hearings, the Klickitat County Planning Commission elected to prohibit growth and sales activities in the county, and the Board of County Commissioners followed up by codifying that prohibition. The land use or zoning process worked just like it should. Commissioners imposed a land use interim control on the county. It delegated the work of zoning and ordinances to the Planning Commission, and the Board of County Commissioners then passed a resolution based on the Planning Commission's findings and recommendations. The exact same process is underway right now. In January, the Board of County Commissioners passed a resolution imposing a moratorium on industrial solar siting in the Knight Road area. Following the hearing, the BOCC directed the county planner to employ the services of the Klickitat County Planning Commission to review zoning and land uses in the stated area. The Planning Commission met last night for the second time on the issue, meets again in a couple of weeks to review data and consider performance standards. The process is just the same as it was in 2013 and 14. The applicant has stated that not accepting applications for industrial scale solar in the affected area is not a land use control. Of course, that is not the case. In principle, it is no different from initiating a moratorium, working through a process, and then restricting marijuana grows or retail storefronts in the county. Moratorium has history in Klickitat County as a land use decision. In addition, the applicant states because a portion of the project occurs outside the EOZ process does not apply, and the underlying zones for permitting utility facilities by a conditional use permit process are applicable. In fact, Klickitat County Ordinance 01121, which was passed well before the moratorium, states that any energy system seeking to connect to the BPA substation on Knight Road would be required to use only the CUP process, regardless of whether in or out of the EOZ. Though the applicant neglected to reference that county ordinance in the application, it is the actual reason Cypress Creek is beholden to the CUP process. So Cypress Creek acknowledges one county land use directly related to utility scale solar near Knight Road, while denying another, the moratorium, which applies to the same area. Klickitat County has faced similar issues in the past. In the 1990s, when farmland was being consumed unchecked by real estate developers, citizens, many of them farmers, got the county commissioners to start a process to review development standards. Shortly after, the Planning Commission recommended the smallest lot size allowed without road and infrastructure improvements was to be 80 acres. The commissioners adopted the recommendation so farmland and agriculture could be preserved. Utility scale solar does not preserve farmland. It is inconsistent with agriculture, inconsistent with Klickitat County Code and ordinances, and I ask you to deny Cypress Creek's expedited application to site industrial solar in this area. Thank you very much.
All right, thank you for your comment. Ms. Grantham, who is our next speaker?
Our next speaker is Elaine Harvey.
And for our last speaker, if you'll go ahead and place yourself back on mute, I just want to make sure that we don't have background noise.
Hello, Elaine Harvey, ELAINE I'm Elaine Harvey. I'm a resident of Klickitat County, also a member of the Comithla Band, which is from this land here. And today, I am concerned about the tribal first foods because this project will impact the first foods of this area. And this is the usual and custom gathering grounds of the Comithla Band, also known as the Rock Creek Band and the Klickitat Band. We still live here. We still gather our foods. This proposed project will directly impact our foods that grow in this area. The ephemeral streams will be impacted, the wetlands, the perennial streams will all be impacted by this project, and that will in turn impact the wildlife and all the different native plants, first foods, and species in the area. And this land, is proposed as industrial solar. This area is not zoned for industrial uses. This land is currently in ag, range, and rural. And the 6 to 8 foot fences with barbed wire is not consistent with the current land use and the existing fences in the project area. And the solar project will impact the views of the city of Goldendale and the views to the Simcoe Mountains and Mount Adams from Goldendale, as well as Highway 97. And this proposed project is within the county's energy overlay zone and should require a full EIS. And this application should not go through an expedited EFSEC tracking process. And also there's, as mentioned before, a solar moratorium. So with Carriger, that just shows their lack of respect to the Klickitat County and the residents of this county who will be living with the impacts of this project, if permitted by EFSEC. And also that this county does not have the critical ordinance or shoreline master plan in place, and that is a conflict. because those are required by Department of Ecology, and you guys are also a state, Washington state agency. So, you know, those need to be in place to protect the resources of the county. And there are federally listed ESA species, which was stated before, steelhead, and this is in the headwaters of the Little Klickitat River, which will impact ESA listed threatened steelhead. And there are western gray squirrels in the area, in this project area, and also ferruginous hawks. So these are some of the concerns I have and reasons why this project is not consistent with the current land use. Thanks.
All right, thank you for your comments, Ms. Harvey. Ms. Grantham, who is our next speaker?
So that was our last speaker. So I will be circling back to those who we couldn't hear or might not be here. So the first one was Justin Sellers.
Justin Sellers, if you're on the line, please unmute and identify yourself. All right, hearing no one, Ms. Grantham, please go to the next name.
Sure. The next name is Delmer Eldred.
Do I have Delmer Eldred on the line? If so, please unmute yourself and state and spell your name for me. All right, Ms. Grantham, please go ahead and go to the next name.
Okay, and the last name I have is Justin Bosque.
Hello, audio check. Can you hear me?
Yes.
Yes.
Oh, finally. Thank you for your time tonight. Name's Justin Bosque, Justin, B as in boy, O-U, S like Sam, Q-U-E-T. And if you're good, I'll just get started.
Please, when you're ready.
Thank you. The permitting process is supposed to take the entire project into consideration. This project is not sited wholly within the county's energy overlay zone. Even assuming the EOZ does permit this solar project in its entirety, including the lithium storage facilities, which people are ignoring, it must be held to the county's standing comprehensive plans. This project is absolutely not consistent with the current comp plan. Klickitat County's comprehensive plan does not address industrial scale solar projects. Stated within Carriger's own application, they would be required to obtain conditional use permits to complete this project, assuming such permits would even be approved. As I previously mentioned and others have stated, the county also does have this standing moratorium over large scale solar. It is a gross misrepresentation of the purpose of this moratorium, as it does address land use for which this project intends to accomplish. Carriger's statement regarding occasional water usage is far too vague and does not accurately depict their tangible usage over time. It is known that these panels require water to periodically clean their surfaces. It would be unreasonable to expect anyone to evaluate consistency for a project without thorough and accurate details about this requirement in its entirety. How can this project claim to not permanently alter soil conditions while it doesn't provide a site restoration plan? It absolutely will alter the land and soil conditions immediately upon the start of the construction. The soil alterations will continue to beyond the life of the project. Carriger does not make claims about how long this alteration will be. Moreover, they do not even provide the site restoration decommissioning plan as required by WAC 463-72020. How are we to discuss land use consistency when the proposal does not contain the details necessary to confirm as such? Carriger continues to make claims regarding consistency without substantiating those claims. EFSEC must deny this project and allow the local Klickitat County officials to work this project through their own existing enshrined process. And I want to take my rest of my time to say thank you very much to my county commissioners for having the morals and courage to stand up and say what we need said to these officials today. I appreciate Dan and Lori very much for their attention and support in as our county leaders, and I hope that they can be put back into place of leading this project and ensuring that the county citizens are protected as we need to be protected. Thank you very much. Appreciate your time and coming back to me.
All right, thank you for your comments. Ms. Grantham, because we do have a few additional minutes, if you would please just do one last roll call for the other two people who signed up to speak tonight.
Certainly. I can go back to Justin Sellers.
All right, and I also see a hand up. We'll go ahead and call that person after we call the two names who've signed up. All right, and I don't hear Justin Sellers speaking up, so please go to the other name who signed up.
Delmer Eldred.
Do I have Delmer Eldred on the line? And your handset might be muted independently of being muted on Teams. So if you just want to check your handset if you are on the line, please go ahead and speak up. All right, hearing nothing. I did see a hand raise on the using the hand raise function on Teams. Ms. Grantham, did you write down that person's name?
I did not, but I believe it was Steve Heitman. Yes.
And I'd like to have one more minute when you get back to the phone people too. This is Commissioner Zoller. Thank you.
All right. Yes, please go ahead and state and spell your name for the court reporter. And then if you have a comment related to land use, please go ahead.
Okay, I'm Steve Heitman. It's H-E-I-T, as in Tom, M as in Mary, A, N as in Nancy, N as in Nancy. I'm also submitting a detailed document as my testimony. I'm a research engineer with several decades of experience, and I've been a strong proponent of and user of solar technology since 1974. I also agree with the commissioner's statements. I voted for one of them. In addition, consistency with EFSEC's existing land use criteria in no way implies that those criteria are complete. In fact, EFSEC needs to complete significantly more groundwork before it can consider certifying any large-scale clean energy project in the state. I base this conclusion on reading RCW 8050. Until this groundwork is complete, we should go beyond Klickitat County's moratorium and get an injunction against all large-scale clean energy projects. Keep in mind, I'm really interested in the clean energy future, and I use solar. We live off grid. So I'm disagreeing with EFSEC, basically. What is the needed groundwork? Stop me if I go too long. I have a long list. EFSEC needs the certification process reflecting unanimity of purpose. We, meaning Washington State, all counties, cities, Native American communities, and energy companies, all need to work together to establish one set of certification criteria for clean energy projects that is designed to accommodate all affected. If a proposed project can't meet negotiated certification criteria of all affected, then it probably needs to be redesigned, relocated, or terminated. I've included in this written document, I proposed a modification of RCW 8050-020, Section 6. As it is, we have a patchwork quilt of city and counties ordinances, concerned citizens, including Native Americans, driving loosely or incoherently defined requirements that EFSEC can consider. However, EFSEC is not mandated by law to meet those requirements and get approval by all affected jurisdictions to certify a project. It needs to be mandated by law, by state law. EFSEC needs cradle-to-grave requirements. EFSEC must establish stringent requirements for end-of-life recycling as a part of the certification process. Spent solar panels, batteries, and electronic components must be properly recycled and not end up in landfills where soil and water can be contaminated. EFSEC must establish a costly consequence for any energy company that ignores these requirements at the end of life for any system component. EFSEC needs to.
Your time has concluded. If you'd like to finish your thought, though, I'll welcome you to do so.
Oh, okay, thank you. EFSEC needs to require safe alternatives to lithium energy storage. The necessary groundwork includes evaluating battery technologies other than lithium. Yes, there are several safer and just as effective battery technologies that are available on the market today. I won't state what their names are because I own stock in them.
And
But,
Mr. Heitman, by finishing your thought, I meant the point that you're making rather than moving on to another one, sir. If there's any final remark you'd like to make, please go ahead. But your comments must include.
Well, the other piece of groundwork needs to identify and study alternatives to mega solar farms because there are lots of alternatives. Complete due diligence requires that we evaluate all valuable clean energy generation technologies before making decisions about Klickitat's clean energy future.
All right, sir. And I'm sorry that I must cut you off at this point, but I do thank you for your comments.
That's fine. Thank you for the extra time. And I'll send a document in so it's really overwhelms with detail.
All right, thank you. And I did just before, or actually, let me go back to Ms. Grantham and Mr. Heitman. If you, okay, I see that you put your hand down. Ms. Grantham, do we have any other members of the public who've expressed a desire to speak?
Not as of right now, so I'm not sure if you're wanting to open up to the teams.
All right, so one thing I would like to address is I believe I heard Commissioner Zoller speak up a moment ago regarding reserve time. And Commissioner Zoller, one concern that I have is that if we didn't provision for speakers to reserve time for rebuttal at the conclusion. If I allow you additional time to make a remark or a closing remark, I must do the same for the applicant.
I fully understand.
Okay.
Okay.
So
thank you.
So with that, we've concluded comment from anybody who's already signed up to speak. Ms. Grantham, we do have enough time for one or two additional speakers. If anybody desires to speak, please use the hand raise function to identify yourself. And Ms. Grantham will call your name in the order that you've raised your hand. And once again, we have time for two speakers. All right, and I do hear somebody that's connected by phone is unmuted. Are you trying to identify yourself to make comment? All right, and I no longer hear that background noise. Let me briefly check. All right, I don't see any hands raised. So with that, public comment has concluded on the land use hearing, and I'm now going to turn this back over to Chair Drew.
Thank you very much, Judge Laripa, and thank you everybody who participated tonight. We will certainly take all of your comments into consideration for all the speakers tonight and appreciate your participation. Have a good evening. This meeting is adjourned.